I would like to take this opportunity to thank Malaysia HR Forum for organizing this AHRP program. I'm also very thankful for the chance to meet many wonderful like-minded people here throughout the program.
Okay, so I also remember about the advice from the CEO of Malaysia HR Forum, which is Mr. Kumar. He always says about AKS, attitude, knowledge and skill.
So first job, don't berkira-kira, work hard. The first 10 years of your working life, and what I've said the other day, the first 10 to 15 years of working life, it's all about hard work. So first job, grab what you can first, take it up, build your experience, build your competencies, learn the skills that you don't have today. The time will come when something will tell you that it is time to move on.
So you have to remember that having qualification doesn't really guarantee you a job, but it can land you with one. But for you to continue climbing the ladder, it's all about skills. And when we talk about skills, of course, not just soft skill, communication, writing, but relates to what you're doing.
What happened between that time until now? I never quit, never lie, and I never want to be somebody other than myself. So if you're a boring person, be boring. If you're an animated person, make sure that animation comes out. And if you're a person that is shy, so be it. The moment you lie, the moment you say you know things and you don't, that's when you won't get the job. At that rate, by the time you are 30, you're going to be having a salary of 7,000 ringgit. Congratulations. But 7,000 doesn't cut it in KL. Learn, continuously improve yourself. This AHRP paper is one of them. Continue to add stuff in your CV.
As a HR professional for many years, the AHRP program, the quality of candidate that we see today, they are well equipped with the confidence, the knowledge and skills of HR, what is it to be a HR person, and all of them coming from other background.
I'm very thankful for Malaysia HR Forum by giving us this opportunity to interview some candidates that they have trained in a 5 days program, and they also filtered the candidates based on their own requirements. And I would say that this is a fresh batch of candidates for us to interview. So it was good, and in a couple of days we will shortlist some candidates and hopefully to organize a second interview with them.
When I first saw it, I thought it was a really good idea to bring candidates together with a specific specialization, which is why I wanted to participate, because I've got HR needs that I'm looking for. So it was a good platform for me to meet a good pool of candidates who have a certification that I can work with. Some of them are meeting expectations. As an organization, I'm looking more towards the ability to communicate, looking at critical thinking, character and motivation of the people. So I think for the most part, I've met good people today.
Overall, it's a good experience to participate this HR Recruitment Day. And I think it's a very meaningful event that helps the fresh graduates out there to have the employment opportunity. Overall, I find the session very fruitful, and we managed to get a few good candidates, and we are going to shortlist for the second interview with our company.
At HRD Corp, ladies and gentlemen, we are deeply honored to be invited as a strategic partner for this conference. This conference stands as a beacon of innovation and forward thinking set against the backdrop of a rapidly evolving digital landscape that fundamentally alters how we work, interact, and grow. These systematic shifts brought about by the COVID-19 pandemic really have underscored the indispensable role of HR in navigating these changes, making our gathering here today more critical than ever.
And we like number of people yang datang, the event.
It's a very wonderful job done. Even till now, we've been part of many events out in the West and in Europe as well.
Having all this knowledge under one roof over 2 days is really useful.
I think the organizer has been doing a great job so far. I think everything else is good. The traffic is great. Yeah, we did enjoy our time here at the event.
I actually quite salute, with how they organize the whole thing, starting from the registration, everything is quite organized, in sequence, in line. And of course, they provide even food for everyone.
A lot of familiar faces. So dia macam nak satu big reunion macam tu.
If it's on again next year, we will certainly be coming back.
The scene here in KL is outstanding, and we hope to join you guys again in the next event.
Today is Thursday, one more day before the weekend, arrives. So are you all able to hear me or see me? If you're able to hear me and see me, please say yes. Give me a yes. Okay, so let's begin. It is now 3:05. We will roughly stop about 4:35. So it's about an hour and a half. So today I'm going to talk to you and share with you on two topics. The first being minimum wage, and the second is the amendment that has been made to Employment Act. right? So today we're going to capture some of the important elements. I will not go through everything in detail because that will take much longer than 1.5 hours. But I will touch on those areas that we feel many are not clear of or unsure of, and so on. So if you have any questions, please post your questions in the chat box. And later part, once I finish the presentation, I'll pick up these questions and try my level best to answer as many as possible within the given time. So once again, welcome to the next edition of our webinar series. So we have done 2 previously. Today is 1, and next week we have another 2. Next week's webinar is going to be on the masterclass recap, as well as the definition of wages. So for those of you all, if you're interested, please go to our Facebook community page, group, or our website, sign up for the next webinar. So the slides that is being shared today will be posted in Facebook group. So right after the session, you can download this from the Facebook group. Okay. Now, so just before I begin, a quick intro of myself. I believe some of y'all do know me. I've probably met some of y'all. My name is Arul, and I was a HR practitioner just like y'all some time back, having had the experience to work for 2 large companies with 9,000 employees, gain as much exposure, experience, into various spectrums of human resources. And today, what I do is I guide, I train. We do consulting work for companies. That's very much about what I do. So I'm attached to Malaysia HR Forum, and Malaysia HR Forum is one of the fastest growing platform for HR practitioners in Malaysia. So those of you all, if you have signed in and you're not yet in our Facebook community, I would encourage you all to sign up. It's free. There's no cost to it. So join our Facebook community. We have over 50,000 members in this community, mainly comprising of HR professionals, business owners. Some of the authorities are also in, as well as like-minded persons. So what can you get from the Facebook community? You'll get tons of resources, webinars like what we are going through today. We have got seminars, HR documentation, and all of these are free, right? So I would encourage you all to join the Facebook community and also get your team members. Sometimes, people ask, I want to train up my young team members. I can tell you this, when we send the young team members for training externally, I would say we are not going to get the max out of it. The learning model says, the learning model talks about 70, 20, 10. 70% of effectiveness is from OJT. 10% is from classroom learning. 20% is from coaching, mentoring. So the best way to train your youngsters is get them into the forum. Every now and then, ask them, what is the latest discussion in the forum? Was there any new documents shared? If yes, can you download the policy or the form, compare against what we have, look into what areas we can improvise, and then take the next steps. That way, they learn better. And many of the issues that you have today, on and off, we have this, can I do this? Can I do that? Now, in order to really master this, is to learn and read and digest as many scenarios as possible. So in the Facebook community, members may ask, I got this issue. Then you've got many other learned members, experienced practitioners. They will share their views, their thought process. And the more you read, right, the more you read, the more we learn, and the better we can when we frame our mind on how do we resolve this issue. Because some of the HR issues are very subjective. It is not binary, yes or no, black or white, can or cannot. A lot of this requires very subjective assessment. So that is why I would encourage all of you all to get all your HR members into the forum, follow, learn, and share, right? So that's very much about the Facebook community. Now, as always, before I begin my slides, I'd like to recap this. Some of you all may have seen this numerous times. And, this one slide says that compliance, right? Compliance is cheaper than non-compliance. If you think compliance is expensive, try non-compliance. In other words, right, when we comply with the law, it is cheaper than non-complying, or when we don't comply. One example is when we don't put our parking ticket, right? If we put a parking ticket, it's only 60 cents for 1 hour, and that's it. But when we don't put, we gamble, we take risk, we take chances. If the town council, officer were to look at your car and if he notices that your car is without the parking ticket, the penalty is 60 ringgit or 20 ringgit or 100 ringgit, right? So compliance is 60 cents, but when we don't comply, it's much more. So what this statement says that compliance, it's cheaper. That means if you say compliance are leceh lah, very expensive, then you try non-compliance. Non-compliance will be even more, right? I'm sure many of you all, if you follow us in Facebook group, you'll notice there's a lot of cases that goes to the industrial court. Just today, there's one case of a company, or it's a kindergarten, employed this lady, a teacher from Singapore, and they decided to terminate her because she could not furnish a work permit. But industrial court says that the company is wrong. And I remember this, if I recall clearly, the penalty or the award is almost 240,000 ringgit or so. I can't recall the exact figure, but 200,000 plus. So just imagine, for a kindergarten to earn 200,000, do you know how much of effort required, how many years, how many months of hard work and so on. And we just now have to just pay this, right? Why can't we just comply with things? Why do you want to take chances, right? It is easier to follow rather than not following. So in this case, as a result, 200,000. And there are many other cases. We have seen cases, 1 million, 500,000, 400,000, right? How do we pay all this? Why can't we just comply? So compliance is cheaper than non-compliance. Agreed. Sometimes compliance takes, it is cheaper, yes, but it takes time. So just because I don't want to wait, I want to do it fast. So we take shortcuts, and what happens when we are in the wrong? It goes to the court finds the company improper, then the penalty can be 200, 300, 500, 800, 1 million, 2 million, right? And I know many of you all, when you go for lunch, we switch off the lights. How much of, how many decades, how many centuries we need to switch off the light to pay for this cost, right? So compliance is cheaper than non-compliance. I would encourage all of you all to run through this one slide before you begin your HR presentation, so that everybody, get in tune with this statement, so that when they want to do anything, they'll remember this. Compliance is cheaper compared to non-compliance. So let's talk about minimum wage, right? I will not go through the entire slides because I've got almost about 60, 70 pages. I won't be able to finish all. But what I'm going to do is, I'm just going to run through some of the very important points, which I think we need to take note of. The rest, you can read it on your own. And if you have more questions, you can always ask these questions in Facebook community, in our group. And I'm sure I will be answering it. Many other experienced members would also, help you out. So the minimum wage, right? The definition of minimum wage is defined not by Employment Act. The minimum wages is defined by the NWCC Act. It's another separate act, right? Of course, it's under Ministry of Human Resources. So the NWCC is National Wages Consultative Council Act 2001. So what exactly is minimum wage? And the definition of minimum wage applies in Peninsular Malaysia, applies in Sabah, applies in Sarawak. Even though Peninsular Malaysia, we follow Employment Act, Sabah follows Sabah Ordinance, and Sarawak follows Sarawak Labour Ordinance, but the definition is same across all these three act and ordinances. And as long as an employee is an employee, right, they have a contract of service, or shall I say, you will need to comply. So it can be foreign workers, there is also contract of service, local employees, permanent, contract, all of them, they are under contract of service, therefore minimum wage applies to them, right? Minimum wage also applies to those who are under apprentice contract. But apprentice contract, it is not internship. Interns are not employee. Apprentices are employees. So minimum wage also applies to them. So as long as they are full-time employees or part-time employees, including foreign workers or including employees who are above 60, the 1,700 minimum wage applies to all of them. However, the minimum wage do not apply to casual workers, right? So for those of you listening in, sometimes we confuse part-timers. We think the part-timers are those who come once in a while, etc. But EA, through the part-time regulations, defines part-time employees as those who are working between 30% to 70% of those full-time hours. So in other words, right, 30% is about 13.5 hours to 35 hours or so. I can't recall the exact calculation. So anybody who works between 13.5 to 35 hours, they are deemed to be part-time employees. Those who are working above 70% of 45 hours, they are full-time employees. So part-time and full-time, they are employees with the contract of service. The minimum wage applies to them. Casual employees or casual workers are those who works less than 30%. So those who work less than 13.5 hours. So whenever you engage them, the total hours that they work is less than 13.5. They are considered casual employees. Casual employees are excluded from minimum wage, right? In some retail sectors, they'll call people to come on weekends during peak season. Can you come and work for one day? Now, they may not be considered as employee if their total work hours is less than 30%. So learn up on this. So those of you all, if you're hearing this for the very first time, learn up what is casual, what is part-time, what is full-time. Domestic servants, they are also excluded from this minimum wage order. So the NWCC, the National Wages Consultative Council, defines minimum wages as basic salary. And it does not include allowances, incentives, or any other payment. Purely basic salary, or in Bahasa we say gaji pokok, purely gaji pokok, which has got to be 1,007. If in a hotel sector, for example, service tips is not basic salary. Service tips is, it forms part of the total wages, but service tip, it is not basic salary. So when you engage somebody, they must be paid 1,007 basic salary or gaji pokok. So that is what the NWCC Act defines, basic salary, and it does not include allowances, incentives, and so on. So that means all your employees, whether they are full-timer, whether they are on hourly rate, piece rated, etc., the basic salary or the basic wages has got to be 1,700, right? So you will get these slides later. You can always refer to the FAQ. I've got a link to the FAQ produced by the NWCC Council, which gives you all this description. So 1st of February, I think many of you all have started it already. So 1st of February, any organization, any company with more than 5 people, you got to start on 1st of Feb. And if your company has less than 5 people, but the occupation, right, the activity that the company carries out, falls under the Malaysian Standard Classification of Occupations, or in short form called MESCO, even if you have one, but you're listed under MESCO, you got to start on 1st Feb. But smaller companies, very small companies, less than 5. When we say less than 5, 1, 2, 3, 4, right? So less than 5 is 1, 2, 3, 4. So if you have, 4 employees or less, right? 1, 2, 3, 4 employees, and your company is not listed in MESCO, you can delay the minimum wage implementation to 1st of August 2025, right? So these are the two differences. So let me repeat again. If you have 5 employees or more, that means 5, 6, 7, 8, 9, you have to start on 1st Feb. But if your company has less than 5, which is 1, 2, 3, 4, you are listed in MESCO, you also start on 1st Feb. But if you're not listed on MESCO, you can delay till 1st of August 2025. And this is the list of classification under MESCO. So you can see there are total 10 groups. So if your company's activity is, you provide professional services, or craft related, plantation, plant or machine operators, etc., then you guys are considered part of the MESCO categorization. So if a company has less than 5, but you are listed here, you will have to start on 1st February 2025. But if your company is less than 5 and you are not listed here, you can delay the minimum wage implementation to 1st of August 2025. So you'll get these slides later. You can see there's a link at the bottom left. You can always click this and to see the full definition of MESCO. So I think I've covered this. So 1st Feb, any companies with more than 5 employees and you're listed in MESCO, regardless of your number of employees, 1st Feb. But those companies less than 5 and not listed in MESCO, you can delay till 1st of August 2025. And this is the minimum wage order. So those employees who are on monthly salary, I think many of you all are monthly salary, then it's going to be 1,007. But if you employ someone on a daily wages, right? If they are working 6 days a week, then the per day rate it is 65.38. If they are working 5 days, then per day rate is 78.46. If they are working 4 days, then the per day rate is 98.08. Some of the part-timers, if you employ them on hourly rate, then the hourly rate has got to be minimum 8.72. You can pay more, but it cannot be less than 8.72. So all these are minimum wages. You can pay more, right? You can pay more than 1,007, or if you're employing someone on daily wages, you can pay them more than 65.38 if they're on 6 days work, but you cannot pay less, right? So this is the minimum wage. Now, in some areas, like for example, in the plantation oil palm sector, they hire the workers on a, they call it either a piece rated or tonnage, right? So whether you hire them on monthly, daily, hourly, or you hire them on piece rated, tonnage, some lorry drivers are paid on trip. They don't have a basic salary, but they're paid on trip or commission. Now, irrespective of what mechanism that you use, the minimum has got to be 1,700, the minimum wages, not the overtime. You cannot include overtime in this, right? So that's what it says. Okay, so the point 3, I need to revise this. So there's a revision made. Now, the apprentices are also included into the definition of minimum wages, right? I will rectify this before I share today. So minimum wages 1,700 applies to all states in Malaysia, Peninsula, Sabah, Sarawak, everybody 1,007. Unlike the last round, there's different rates, but now it is same rate for all. So in order to define what is minimum wages, so we need to look at, right? We need to look at National Wages Consultative Council Act as well as what EA says. So if you look at this on the right-hand side, NWCC Act says that the wages, right? When we say wages, right? It is the same as what is defined in Section 2 of EA, which is on the right-hand side, the green box, same as Section 2 in Sabah Labour Ordinance, same as what is described in Section 2 of Sarawak Labour Ordinance. So let's look at the Peninsular Malaysia, which follow Employment Act. So wages means basic wages, which is basic salary, gaji pokok, 1,700, and others, right? So 1,700 and other payments. So if you are giving allowances, shift allowance, let's say, attendance allowance, all this cannot be part of 1,700. 1,700 is 1,700. These are all extras. So it is 1,700 plus your attendance allowance, your shift allowance, maybe your mobile allowance or whatever allowances you give. So 1,700 plus others. So minimum is 1,700, right? And the definition of wages do not include if you're providing a house, you supply food, or contribution to EPF, traveling allowances, right? That is not included. Transport, yes, but not travel. Or if you provide any money to employees because their nature of work requires them to, there's some expenses that they need to bear and the company reimburses them. Now, this is not wages. Or if there's a gratuity payment or retirement payment or bonuses. So A, B, C, D, E, F, it is excluded from the definition of wages. So wages means purely basic wages or basic salary of 1,007 and other payments, excluding A, B, C, D, E, F. Got it? And so apprentice contracts are also included. So who are apprentices? Apprentice contract, typically you look at those skill-based programs, they come and work for 2 years, they work and learn, etc. Those are apprentice. So apprentice program, as long as they have an employment contract, they are also considered, apprentice with employment contract, they are employees as well. So EA says that apprentice contract is a contract, entered between a company and employee to train them, right, systematically for a period of time. And the minimum is 6 months duration and maximum is 24 months duration, right? So if you hire apprentice, you will also need to pay minimum wages, right? So late last year, the government has amended the NWCC Act to include apprentice into the minimum wage order. So these are some questions. I'm not going to run through this. You can read this. So these are all FAQs, because typically people ask, what is this, what is it, etc. So we have, tried to address as much as we can. So these are all the various questions that you may ask. For example, is there any industry exempted from minimum wage? The answer is all industries are covered. In the minimum wage order, no exclusion is given. For example, okay, plantation, you're excluded. No, all industries are included. If I hire somebody on a fixed term contract, should I pay minimum wage? Answer is yes. Whether they are full-time, permanent contract, fixed term contract, local employee, the foreign workers that you have from, let's say, Nepal, Bangladesh, India, Myanmar, etc., all of them, they are also entitled or eligible for minimum wage. Above 60, if I were to rehire someone who has retired, can I pay below 1,007? Answer is no. They are also employees. They have a contract for service. You got to pay them 1,007. Okay, internship are different. Interns, they come for latihan industry. They are not employees, and you're not bound. They're not bound by the minimum wage order. So for them, if you're going to pay 500, 300, or 1,000, that's up to you. But they are not they don't qualify under the minimum wage. So part-timers, yes, right? Again, part-timers, of course, they may not get 1,007 if they're not working full hours. But if they work full hours, 1,007 is applicable. So let's say we are paying hourly rate. Usually for part-timers, I think most companies pay them on hourly rate. So hourly rate, remember we said just now, that hourly rate has got to be followed. You can pay more, but it cannot be less. Right? So I'm going to leave you with all these FAQs. There's a couple of pages. Please read it, right, for you to better understand what are these. So it's quite a bit. Whenever I prepare slides, I always have FAQ. So before you ask me questions, the questions are already answered here. So that as HR, my life is much more easier. I don't have to sit down and crack my head answering a question. And typically what happens in organizations, when you launch a policy or a framework or a program, and if you don't give complete info, people will start to come up with their own interpretation of things. So having an FAQ, then your communication is constant. Everybody speaks the same lingo, right? That is why having FAQ really helps. And I always encourage all HR practitioners, when you launch any framework, policies, processes, you're making changes to something, etc., have a simple FAQ. Think of all the questions that people will ask, so that when you speak, when you present to them, you cover everything, right? Now, what happens when company fail to follow, right, the Perintah Gaji Minima? That means you don't follow the minimum wage order. In the NWCC Act says that for the first penalty, a fine of not more than 10,000 per employee. This in EA minimum is 50, but max is 50. Here max is 10 because this is a different act. The general penalty not more than 10,000. But if let's say we keep repeating it again, then it is maximum fine of 1,000 per day. Per day, if let's say this offense continues, or maximum fine of not more than 20,000 or 5-year jail term, right? Maximum 5-year jail term. These are penalties, right? So in short, please comply. If you think compliance is expensive, try non-compliance. Right, these are some, this was taken from the minimum wage order FAQ. So who can you call if you need further clarification, further guidances? These are all the contacts: the Labour Department, the IR Department, etc., the Secretary for Minimum Wage. So these are the, parties that you can call in order to clarify any, confusion or any, questions that you may have. So there's also FAQ prepared by the NWCC Council. So I would encourage you, when you get this slide, there's a link there. We've shared it in our Facebook community group. So you can click on this and read the FAQ, quite a thorough FAQ as well. Okay, now what happens, right? What happens if you have already complied to minimum wage? So those employees who are below 1,007, you bring them to 1,007. But what about employees who are currently earning 1,007, 1,008? They will feel it's unfair. The new guys who join, right, after high school, they are paid 1,007. I am working for the last 3 years. I'm also paid 1,007, right? So this is what we call as a compression. So this group, they are being compressed. The new guys and the older guys, they are being compressed in a very similar salary band. So what do? Right? You can keep them there, but they'll feel unhappy, or you move them. So there's a few mechanisms how you can move them, right? There are 4 approaches that we are sharing here. So approach 1, you can move them based on a fixed quantum. Okay, everybody plus 200, so that they are away from 1,007, right? That's one option you can do. or you can go on a fixed percentage, okay? If you're earning 1,007, 5%, 10% or whatever. Option 2, which is similar to option 1, universal adjustment, that means you adjust everybody, or you adjust them based on performance. So, for example, if you're an A performer, your adjustment is X amount. If you're a B performer, your adjustment is Y amount. So you can defer the adjustment based on the performance, which I like it the most. If the employee is a poor performer, why should I adjust him? Right? That's your call. Or you can adjust them based on fixed amount based on their salary bracket, right? So if they are earning, previously they're earning 17 to 1750, you adjust them this much. So different salary bracket, your adjustment is different. Okay, option 4, you can give, again, it's very similar to option approach to option 2, which is you give them a merit increment based on their performance, right? So very similar, but there's some differences there. So these are some explanation of how you can move them. I mean, it's going to be a little bit lengthy. I'm going to leave this with you. You can read it. It's quite easy to understand, but you got to really focus and digest. So this is approach 1, approach 2, approach 3, right? This is what we said. Different salary bracket, you move them, universal movement, but by their bracket. So for example, those who are earning 1750, 1700 to 1750, you move them to 100. So you can see here, everybody is moved. It's not necessarily 200, but you can see everybody is moved quite consistent so that they are away from the 1,007. But those people who are currently earning 1950, 2,000, you can see their increment is a little bit lesser compared to the others. So please have a look at it and read it. Okay, so this approach 4, right? So that's very, that is a little bit on the minimum wage, right? If you have any questions, please ask in the chat box. Now, let me go through the Employment Act amendment that took place 2 years ago. Actually, this is already old story, but I think many are still, there are some questions on and off, this and that. So I'm going to run through this. This is almost about, 50 pages plus. So I'm going to run through this briefly, not everything. But if you have any questions, please ask in the chat box. So we all know that one of the reason of government making this amendment is to comply with the requirements of the CPTPP agreement, right? And also to comply with the International Labour Organization standards, right? Recently, we heard the government says that even foreign workers, we got to start paying them EPF so that, we treat everybody, there's no discrimination. So that is one of the, one of the objective of what ILO is trying to tell countries, treat everyone fairly, right? So that is why the foreign workers, eventually starting next year or so, we will be paying them EPF as well. So this is the very purpose of why the Employment Act was amended. So now that we've amended the Act, we are able to join a much bigger, wider group of these countries. And now Malaysia have, better access to a US 28 trillion economy. And who gains end of the day? Do we gain as a country? For sure. But who are those producing goods and services? It's your company. So the country gains, your company gains. Then the next question is, shouldn't the employee also gain, right? So we all know that the enforcement went live on 1st January 2023. And one of the major changes, one of the most significant changes in the amendment was the changes to the first schedule, or the amendments to first schedule. Now, I'm going to skip this slide so that, this is a bit difficult to understand, but let me just briefly read this to you. You can see previous is what was before, and amendment is what has taken place. So in the past, right, EA applies to those employees whose wages, do not exceed 2,000. So if they're 2,000 and below, they are covered under Employment Act. But today, you can see what has been, changed. As long as the employee has entered into a contract of service, he is covered under Employment Act. So in other words, it's no longer just the operators and the technicians, the HR manager, the finance manager, HR exec, finance exec, your sales manager, your R&D manager, your accounting, your tax manager, your CEO, your director, if they're paid, right? If they have a contract, they're paid as an employee. Even the CEO earning $100,000 a month, he or she is also covered under Employment Act, right? As long as they have a contract of service. your employment contract. As long as they are employed as an employee, it doesn't matter what salary, they are covered under Employment Act. However, there are 6 provisions which you can see on the, at the box on the right. So these 6 subsection do not apply to certain category of people. So for example, rest day pay, right? If they're working on overtime or normal days, or allowances for shift work, or if they work on a public holiday, right? Or if you're going to retrench them, then the termination benefits do not apply to this group. So I'm going to skip a few slides. I'll come back here later, right? For ease of understanding. So you can see this slide, right? When you read the first schedule, it's a bit confusing, it's a bit tricky, especially if you're new, you may not be able to understand better. But this table clearly illustrates it. So what you can see is there's 2 categories of employees. On the right-hand side, on the left-hand side are those employees who are engaged in manual labor, right? So you want to know what is the definition of manual labor? You can see 2 links at the bottom. So manual labor, those who operate or maintain any mechanically propelled vehicle, or those who are supervising, or if they oversee another employee who is engaged in manual labor. So this group, right, those manual labor, your operators, your technicians, your lorry drivers, your supervisors, etc., it doesn't matter whether they're earning below 4 or above 4. Some supervisors are paid 5,000 ringgit, right? Some technicians could be paid 5,000 ringgit, or even 4,500 or 7,000. As long as they are in this category of manual labor, mechanically propelled vehicle operated by them, or if they supervise another manual labor. Now, it doesn't matter whether their salary is below 4 or above 4, all those 6 items applies to them. So if you're going to terminate this group, you got to pay termination benefit. If you're going to ask them to do overtime, they got to be paid OT. So if you have a lorry driver, right, if he is being paid $7,000 a month, ringgit a month, he also would become eligible for overtime, right? Now, then you have got the other employees. I think most of y'all, if you're in HR, finance, you're a CEO, you're a director, or you're a payroll officer, and you're earning below 4, right? If you're earning below 4, then overtime, rest day pay, if you are going to work on public holiday, the public holiday pay, termination benefit applies to all of you if you are earning below 4. But if you're earning above 4, right, I call this a red box. If you're earning above 4, then OT, rest day pay, pay for work done during public holidays, termination benefit do not apply to you. So if I'm going to retrench a HR manager earning 4,500, no retrenchment benefit is payable. If I'm going to retrench a HR manager, title HR manager, earning 3,500, they are in the green box. So if they are in the green box, I have to pay termination benefit. If they do overtime, I got to pay overtime. So it depends on, so it is not the title. Sometimes smaller companies, they give big title, small pay, right? So it is not about a title, it is about the job that they do. So if they're earning below 4, they're in the green box. So all those in green box, that 6 items is payable. Red box, the 6 item is not applicable, right? So coming back here, so you can see these 6 items do not apply to those in the red box, right? So you got to determine who are those in the red box and who are those in the green box. So this is one of the major changes in my view, which includes everyone into the act, but excludes certain provisions from those people in the red box, right? You got to know this so that the next time when you are going to, if you're going to retrench someone, so you will know whether termination benefit is applicable or not applicable to this particular group of employees. An apprentice, we discussed just now, the minimum period is 6 months, the maximum is 24 months, right? So those people that you hire as apprentice, if you if you submit them, right, you inform Labour Department and it's approved, then section 10 to 16 do not apply to them. So one of the section here is termination, right, for those apprentices. But if you do not submit to Labour and it's not approved, then section 10 to 16 applies to the apprentice. Calculation of incomplete month of wages. So I think this formula all of you are very familiar. If the employee did not complete the full month, either he started late or he completed earlier. That means he only started work on 15th of April, or he, ends his employment on 21st. So what formula do you use? This is the formula. Wages, monthly wages, divide the total number of days, calendar days, in the wage period, times by how many days that he has been employed. So this is the formula. I think many of you all are very familiar with this formula. Now, pregnancy, maternity used to be 60 days. Now it is 98 days. And why 98? Because ILO's recommendation is 14 weeks. 14 times 7, 98. So what it says here, an employee, whether she receives a maternity allowance or not, she can come back to work. If she wants to work, she can come back to work earlier than 98 days, provided two conditions. One, you as an employer, you have said, okay, you can come back. Number two, the doctor has certified her to be fit to resume work. So these two conditions must be met if they want to come back. Now, if you ask me a question, so what happened to the maternity allowance that they're getting? If they come back early, you got to still pay them the maternity allowance on top of the salary, because the salary will resume, right? So you'll be paying two items for that short period. Work hours from 48 has become 45, and there's a new provision created at the bottom, subsection 2A. In future, the minister may make regulations pertaining to allowance during shift work. So this is something new created. So in future, there could be one fine day, night shift regulations, whatever year, and it explains what company need to do, what are the allowances and so on. But at this moment, such regulations are not there. So 45 hours. But do you know, right? Do you know that ILO's recommendation for reduction of basic hours is 40, not even 45? But our government decided to stop at 45, but ILO's recommendation is 40, right? So for now, you comply with 45. So if it's going to be 6 days work, then the work hours per day cannot be more than 7.5. 7.5 times 6 is 45. If the employee is working 5 days, then your maximum hours per day, working hours, right, exclude break, because break is not work hours. Excluding break cannot be more than 9 hours if it's going to be 5 days work. But remember this, if you're going to ask the employee to work more than 8 hours per day, for example, 9 hours, you must get the employee's consent. 8 hours is fine, but 9 hours, you must get the employee's consent. And sick leave and hospitalization leave, it was together, but now it's separated. They decided to divorce each other. So what used to be 14, which is part of the 60, total 60, now it is 14 and 60, right? 18 and 60, 22 and 60, right? For some employees, this is good news because, many of you all, or, we define sick leave as if you're not feeling well, see the doctor, doctor gives you an MC, you rest at home. But for some employees, they abuse it. For them, this is cuti tahunan tambahan, right? So you got to have your control mechanism, how to manage this, right? How to prevent employees from abusing your sick leave, right? So 74, 78, 82, sick leave and hospitalization leave. So now employees has better benefits under Employment Act. Paternity, 7 consecutive. That means it's in a block, right? If the paternity starts on Thursday, 7 days, right? It includes Saturday, includes Sunday, includes public holiday. And this is only for the first 5 confinements, right? Irrespective number of spouse. If the employee has got 2 wives, it is still total 5, not 10, right? So irrespective number of spouses. And he will qualify for the paternity allowance so long he has worked for you for 12 months. So if you put a condition in your company policy saying that the paternity allowance is only, only confirmed employees are eligible. If the confirmation less than 12 months, no problem. But if the confirmation process takes more than 12 months, that clause becomes irrelevant, because the moment he completes 12 months, the paternity leave, he is automatically eligible for paternity leave. Now, what about foreign workers? Those male operators from Bangladesh, Myanmar, Cambodia, Indonesia, do they qualify for this? Answer is yes. EA do not discriminate. EA provides all the benefits to everyone, irrespective whether they're local or foreign, permanent or contract. Everybody gets it, right? Even the part-timer, they are also eligible for this. Casual workers, no, because they're not employees. So part-timer, full-timer, permanent staff, contractual staff or those on fixed-term contract, local employees, foreign workers or foreign employees, all of them are eligible for paternity, maternity, sick leave, hospitalization leave, annual leave, right? They're eligible for all of this, public holiday and so on. Okay, now, so for those of you all, if you want a form, right? Sometimes how do we monitor this? We have shared a form in the forum, how to manage this, right? If you want, you can always download it. And section 60K, right? The previous section has been substituted with the new section, right? Which says that, I just want to highlight one item, right? The one in red. It says that section 60K says that no employer shall employ a foreign employee without prior approval obtained from the Labour Director General, the Labour Department. So in other words, you cannot hire a foreign employee, whether it's an expatriate from Singapore or China, or a laborer from, the manual worker from Indonesia or Bangladesh. You cannot hire any one of them without obtaining approval from the Labour Director General. So now, if you still go ahead and get these workers to work for you without permission, then if you look at right at the bottom, if you commit an offense under subsection 1, which is what the red item is, then if you're convicted and you're found guilty, a fine not exceeding 100,000 ringgit, that's a lot of money, 100,000 ringgit, or imprisonment for a term not more than 5 years, or both. It can be both. Maximum 100,000 or maximum 5-year jail term, or both, right? So it's a very heavy offense, hiring a foreign employee without permission. Now, this is the Employment Act. Immigration has got their own ruling. So, don't have this situation where you're caught by labor, you're caught by immigration, now you pay a very heavy price. Compliance, if you think it's expensive, try non-compliance, right? Now, some of you all may ask me this, yeah, all our workers, we go through Labour Department, but what about employees that you hire illegally, you ask them to come and work, no work permit? Personally, my view, you are employing them. What is the definition of employ? When you get somebody, you pay them salary, you give them a job, you pay them a salary, you are employing them, right? Of course, this is not been tested yet, but be cautious not to engage any foreign employee without obtaining approval from the Labour DG and of course immigration for the work permits, right? And flexi work, right? This is something interesting. So flexi work is another addition into the amendment. So what it says is an employee, right? All employees today, you cannot say no to them. They can come to you saying that, boss, can I change, very means change. Can I revise, can I change my place of work, hours of work, days of work, right? I want to work from home, can or not? Can I change my work hours? Can I change my work days? Right? They can apply. The law says they can apply, right? An employee may apply. If you have if your organization has a union, right, then whatever this point 1 says, that it must be consistent with your terms and conditions of your collective agreement. Now, section 60Q says that an employee, they can make an application to you, right, under section 60P, using a form and manner as may be determined by the Labour DG, right? There's a form and manner. Or some companies, they have their own form. They've taken the labor's sample and incorporate into theirs. But you don't have to get approval from Labour Department, right? Employee will fill up this form and come and give it to you, boss. Saya nak mohon kerja flexi, right? Now your job, what you need to do when employee applies, there's only 2 things. One, you either reject or you approve it. If you approve, well and fine, everyone is happy. But if you reject the application, so what subsection 2 says that within 60 days, right, when you receive the application, within 60 days, you must decide yes or no, right? If you approve, it's good. If you don't approve, then you must inform them in writing, not just verbal. You must inform in writing why did you reject the application, right? So you cannot just say, tak boleh, cannot. You can't do that. If they apply, you must, if you're going to reject, you must inform them in writing why you rejected the application. If you don't, if I'm the employee, I can go to labor and tell labor that my company, I applied, but they don't give me an answer. Already 60 days, right? I don't think you want to get a call from labor. So please comply. If an employee applies within 60 days, yes or no. If it's a no, please provide your explanation. That's number one. Number two, watch out for discriminative practices. For example, if two employees are in the same job category, let's say two clerk, there's two HR clerk, same job category. One person you give approval, the other you don't give. Now, this particular employee will say that my company, practices discrimination at work. The other employee, same job category, everything is same, but he or she got it, but I didn't get it, right? Then the issue of discrimination will crop up. So that is another offense, right? So you got to be fair, right? Be fair, be transparent, set up your policies. So if you want a sample policy, quite a comprehensive one, go to Facebook, our group. There is almost a 5-page policy, a sample policy on flexi work arrangement, right? Take the policy, see what is relevant to you, not relevant, remove it. What is relevant, you keep. Maybe you can enhance it further, and that is your policy. So my advice to organization is this. Gone are the days, you can have all the flexibility and freedom to say yes or no. Now there's a law, right? Employees can apply, you got to say yes or no, and if you say no within 60 days, give them an explanation writing why it's a no. So my advice is this. If you want to play hardball to your employees, and we are now in year 2025, he will say, you know what, Mr. John, it's okay, like you keep your job. I'm going to another company. They are giving me flexi work, right? They can also do that. Or they may say, how much are you paying me? 2,000 ringgit or 3,000. Why should I work for you for 8 hours a day, 6 days a week? I just go and drive Grab. I can earn 4,000, 5,000 in Klang Valley or even more. I can be an influencer. I can do Grab food, right? There's so many jobs out there today. So companies, if you ask me, we are no longer 1970s or 1990s or 2000, where options are limited. Today, options are plenty. A lot of youngsters today want to be influencer, right? They want to do many things. So many things the internet has enabled, the advancement of internet has enabled so many other opportunities for them. So you want to play hardball, be prepared to lose your employees. So to me, there are some, there is some flexibility you can give. For example, operator, right? This is our simple metrics. Operator, can the operator change place of work? Cannot. You must come to the factory because the equipment is in the factory. You can't work from home. Can you change work hours? Maybe not possible. If you're if it's a 12-hour shift, rotational shift, everybody's got to follow shift hours. Otherwise, kelam kabut, right? Huru hara. It's going to be chaos. So work hours cannot. But the days, I feel you can. Same, a clerk, maybe clerk, if your company is automated, you got laptop, clerk can work from home, right? But a security guard, place you cannot, because you got to come and jaga here, not at home and watching the camera, CCTV via your phone. You can't do that. You got to be on site. The hours of work may be not possible because if it's a rotational shift, for example, even I can tell you, if the guard is working, your company operates single shift, even hours can be modified. Work days can be modified. Of course, the engineer group, executive, managers, this group, yes, they can do their job while at home because laptop is there, everything is connected, right? They can change the hours of day, place of day. So it is good to have a matrix like this. Once you've decided, then you decide what kind of flexi work that you want to do. Maybe flexi hours. Maybe you want to change your shift, right? Your shift pattern, compressed work week. So we have done another webinar a couple of weeks ago, the flexi work arrangement webinar. The recorded webinar is in the forum. It's almost a 2-hour webinar done by me, right? I covered this in detail. So if you want, you can go to the Facebook group. There's a recorded webinar you can watch. The slides are also shared there, right? Details into what is flexi hour, what are the shift change model, compressed work week, how do you implement hybrid work, part-time work, and many others, right? So to me, given the environment that we are in today, it is good to have some form of flexi for everybody, right? Not just the laptop group, right? Those with laptop, okay, you can work from. Those no laptop, work, right? So sometimes the employee will say that, all of us are, together in this. I'm running operations, production, I'm producing results for the company. So why is it a manager can enjoy, I cannot enjoy? We say what? People are our assets. We are one family. So what happened to the one family when the manager can have some flexi, but the operator cannot? Right? People talk about fairness here. Now, discrimination, right? I mentioned this just now. Now, the new section 69F, it replaces the previous discrimination section. It says that if there's any discriminative practices in employment, right? If an employee complains, there's a dispute, employee complains, raises a complaint, the labor director will investigate. And if it's found true, what will happen is maximum fine not exceeding 50,000, that means the maximum fine of 50,000. And if this offense continues, then a daily fine of not more than 1,000 every day, right? So take note of it. And so I'm going to, the other item is the requirement to exhibit. That means you are supposed to put up notice on sexual harassment prevention at your workplace. You must exhibit conspicuously. That means you must put it in a place that everybody can see. Now, if you have not done that, if you have not put up these notices, 50,000 maximum fine. So for those who have not done it, there are 9 sample notices in the forum. Go and search in the forum, sexual harassment awareness posters or whatever, download it, put a logo and put it up on your wall, right? Otherwise, 50,000. Remember, compliance is cheaper than non-compliance. Okay, so forced labor. So this is another new section created, forced labor. What it says here, an employer who threatens, you threaten the employee, you cheat them, you deceive them, you force them to do any activities or work, and you prevent them from leaving their place of work, right? This could be deemed as forced labor. And if the company is found to have committed, actions of forced labor, again, maximum fine of 100,000, that's a max fine, or imprisonment, that means jail term of not more than 2 years, or both. So 100,000 max, 2-year jail term max, it can be either one of it or both, right? So it's a very heavy offense. Forced labor and hiring of foreign employees without permission, this too has a jail term and a max fine of 100,000 ringgit. So don't do it, right? What is forced labor? Forced labor is very subjective because there are so many areas to look at. What EA has given is I would say is more of a basic guideline, but for example, deceive. You promise the employee something, but you don't deliver. That is one form of deceive. You promise them a job in Kuala Lumpur, but upon arrival, you send them to Johor, right? How would you feel if you are going to work in Singapore, right? You were promised a job in Singapore, but you end up in Cambodia. You feel cheated, right? So are we being fair and honest to the foreign employees that we hire? We promise them a job as a factory operator, but upon arrival, they're asked to work as a cleaner. Is it fair to them or not? During interview, we promise them a factory job in Kuala Lumpur, but upon arrival, they are moved into cleaning job, right, in another location. If you had told me, if I'm the worker, right, if you told me when I was in Bangladesh, if you had told me you're going to be a cleaner, maybe I won't take up the job. But you told me it's going to be, the job is like this, like this, like this. Upon arrival, I'm asked to do cleaning job, right? You will feel cheated. But what about these workers? I always tell this to employers. We cannot be, we pray to God. One hand, we pray to God, right? Whether you're Muslim, you're Christian, Hindu, Buddhist, whatever, etc., we pray to God. But on the other hand, we treat another human being like garbage, right? We treat them, we don't give them proper treatment. We treat them like slaves. How do you do that? All, pray all cannot, gone, hapus already, finished, right? So remember this, when we, as a human being, we believe in God, we got to treat another human being with respect and dignity. So if you promise them something, you should deliver it. Okay, and what has happened is the minimum fine of 10,000 has become 50,000 now. So all other, any other offenses, unless it's provided for, it is maximum, not minimum, maximum 50,000 ringgit. And another new section created, section 101C, who is an employer, who's an employee. So what it says here, very simple, right? Now, if you don't have a contract of service, right, there's a contract is not there, how do we determine whether you are the employee or that person is an employer? So, quite clear guidance, if the work is being controlled, right, you control the person's work, and you control his work hours, you control the movement, you provide him tools, or whatever job that this person do is a very important part of your business, and is only working for you. He's not working for anyone else, only for you. And whatever you pay him is a major part of his income. So if this is a scenario, you are the employer, that person is the employee. Let me give you another example. What happens, let's say a cleaner, in a corporate tower, a cleaner will come to your office Monday, 2 hours, clean up your office. Then she or he will go to another office, another 2-3 hours, finish, go to another office. And the whole week round, this person will go to different company to clean up. So now, is this person only working for you? No. Is the person doing something that is very important part of the business? If you're an IT firm, is this person coming to IT job? No, coming to cleaning job. Whatever that you pay this person, is it a major part of the income? No, you're only giving a fraction of their income. And are you controlling their movement? No, they're free to go. They come 2 hours, finish, I go. So this cleaner is not an employee. You are not an employer. But compared to earlier on, you control the movement. This person doing, whatever that he or she does is important, it's an integral part of your business. You control their work days, you control the work hours, and whatever you pay is a big part of the income, a majority part of the income. That person is an employee. So I hope you can see the difference. Okay, so that's very much on the amendment. I've done, quite a bit on the amendment. Let me just run through a few key items, right? So this is the FAQ. As I said, I am a FAQ guy. So whenever I prepare anything, I present something, there's always FAQ. Now it is many pages. So please read all of this. I just want to bring you to a few areas which I think many people are not clear of or they're unsure, right? So these are all the FAQs. Please read these FAQs a lot. Paternity, maternity, night shift allowance, wages, flexible arrangement. What do we do if like this? What do we do if like that, etc. So please read all of this. I would like to bring you to one item. So break time. Break time is excluded from work hours, right? It's not included, it's excluded. You can see that under section 60A9, right? Overtime, right? Work hours, how HRP and all this. Should I divide 8? Should I divide 7.5? If the employee works 7.5 hours every day for 6 days, then the ORP formula, you divide 7.5. But if they work 5 days, 8 hours per day, then the ORP divide 8. Okay, so I would like to just, so this is the one. So how do I determine 4,000? So as we know, if you look at what first schedule of EA says, to determine 4,000, we only take into account the basic wages and all other payments in cash. Do we include housing? If you provide housing, no. Housing allowance, yes, but not housing, right? If you provide housing, you supply food, right? EPF contribution, traveling allowance not included, or retirement benefit, bonuses, commission, subsistence allowance, overtime. All these are not included in determining the 4,000. So it's a quick example. So these are 4 examples. Example 1, 4,000 ringgit, only basic salary 4,000. Yes, he'll be entitled to overtime, public holiday pay, termination benefit. Illustration number 2, basic salary 2.5, allowances 1.7, no OT. So the total OT we don't include. So total wages 3,007, then overtime is applicable. Termination benefit is applicable. What if the person earns 3.8, allowances 1.5, but he gets a commission of 200? So commission we do not include to determine the 4,000. So in this case, the wages is below 395 is 3,950, therefore eligible for overtime. Illustration 4, basic salary 3.8, allowances 300, so total is 4,001. Now in this case, it exceeded 4,000, therefore, person number 4 will not be eligible for overtime, termination benefit, and that few other items, the 6 items. The 6 items do not apply for illustration number 4. But illustration 1, 2, and 3, it becomes applicable. Okay, so what is on forced labor? These are, many things that you can read on forced labor. What does ILO says about forced labor, right? Please read all of this, right? Sabah, Sarawak. Now, EA applies only to Peninsular Malaysia. But I think many of you all will be aware that in the recent months, the ministry, the government has also updated, right? Has also amended the Sarawak Labour Ordinance, Sabah Labour Ordinance, included many of these items that we have spoken of, right? Apprentice and interns, they are not the same. Interns are not employees, but apprentice, they are employees. So probationers, they also enjoy, like for example, sick leave. some companies, they have this idea, I don't have to give sick leave to probationers. No, sick leave, hospitalization leave, the entitlement is from day one. Annual leave, yes. You can delay the annual leave either for the first year, you can give them after completing 12 months, or you can give it to them after they complete their probation. But public holiday, public holiday, sick leave, hospitalization leave, maternity leave, right? They are eligible from day one. Paternity, of course, after 12 months. Maternity, there's some criteria, but less than a year, they still qualify if they fulfill the two conditions under maternity, right? So these are all some FAQs which I'm going to leave it to you. Please read it, right? Okay, so just before I go into the questions, so now if you think that what I've shared is good, etc., I would encourage all of you all to join the masterclass. We will go through this in detail, plus many other things, how to simplify your processes, how to do things right, how to safely terminate an employee with medical conditions, how can I work smart, how can I resolve IR issues, in shorter time frame than what you're doing now, revising policies, how do I manage disciplinary issues, and so on and so forth. Some new ideas, new methods, how to simplify your processes, how to do things right. So all these are covered in a 2-day masterclass. It's fully claimable by HRD Corp. So if you're interested, our next session on 15, 16 April, the trainer is yours sincerely. So I'll be doing this training over 2 days, comprehensive, compact. I would also encourage business owners. It's not just HR. Even business owners, if you are a business owner listening today, I would encourage you to join the masterclass, because sometimes your HR don't tell you a lot of things, right? So if you are a business owner or you're a business leader, you want to have things within your grip. You want to understand what the law says. How can your company be a successful company? How can you do things right? How can you avoid costly mistakes, costly savings, right? How do you increase your employee motivation, etc.? We cover all of this in the masterclass. So if you're a business leader, business owner, don't try to save this 3,200. You will find that the lessons you learn is worth hundreds of thousands of ringgit. So please join. I wish all of you all listening today, all 300 of you all today or so, please join this masterclass. It'll change your perspective. Now, at the same time, Malaysia HR Forum also have certification programs. Now, these are some of the certification programs: Certified TNA for L&D professionals, Certified Strategic Human Resource Manager, Payroll Professional, Com and Ben, HR, basic certificate for HR professionals, certificate for HR business partner, IR practitioner, that's one of the best sellers that we have, or recruitment professional. So these are all the certification programs that we have for those who are interested, right? If you're interested, do join us. As I said, in order to be effective at our work, right? We want to be good at our work. We want to do things right. We want to be better. We want to help the company to grow. We cannot use yesterday's knowledge to resolve today's issues. Today's issues, we need today's knowledge, right? So instead of working cluelessly, blindly, do not know what to do, calling labor department, calling here, calling there, calling everywhere, etc., upskill yourself, learn what is needed, right? And be a better HR practitioner. So these are some certificate programs that we have. Okay, so now I'm going to take on questions, right? So my colleague here is going to help me to, is going to pop up the questions. So just give me a minute. So if you have any questions, right, please post in the text box and I'll try my level best. We have roughly about 25 minutes. I will try to cover as much as I can within these 25 minutes. Okay, so let's scroll up. Okay, so ready? Okay, so let me pick up these questions one by one. I'll try my level best to answer as many as I can. So if the employee is on commission base, there's a question from Junius Lee. If the employee is on commission base, and if the employee who works on commission base, if the employee is not entitled to commission for that particular month, do we still need to pay? The minimum that you got to pay is 1,007. Why are you not giving this person enough job? As long as you've given the person enough job to do, but they don't do, that's a different story. But if they do, they got to be paid. But if you fail to provide them a job, you still got to pay them, right? So you cannot say commission based and you don't provide a job. Just like all of us. If I'm prepared, I come to work, I'm prepared to do my job. As a company, you're supposed to give me a job to do. If you don't give, you still have to pay me. Right? Okay, next. So what is the difference between apprentice and internship? Apprentice are those who are coming to learn and earn, right? They've gone through their SKM, or they learn, work for you for 2 years. Those SKM guys, right? Some of these programs, they work and earn. That is called apprentice. Interns, they're only for 2 or 3 months as part of the degree, right? Finish degree, finish the internship, they go back and continue the degree or diploma. So those internships are not employees, but apprentice are employees, right? So protege, now this is a bit tricky for me to answer. Now, this protege may be deemed as apprentice. Why? Because they're working full-time, they've already finished the degree. Whereas interns, the purpose of internship is one of the condition as part of the degree program. So they're not employees. They're coming to you, to do their internship because they need to fulfill the condition of the diploma or the degree. Whereas protege, they've already finished studying. So when they come to you, that contract, in my view, it's a contract of service. So, okay, so scroll down. Okay, so there's a question by Zera. I have one situation. Before, the company complied with 1,005 and they give 500 ringgit allowance. Now the company follow new minimum wage order 1,007 and only give 300 allowance. So what this company have done is, it used to be 1,005 plus 500. So they've taken 200 from here and put into minimum wage. So now it has become, the total wages remain the same, 2,000. 15 plus 500. Now it has become 17 plus 300. I don't think it's acceptable. So Zira, I would like to encourage you, I advise you to seek guidance from Labour Department. Right? The company cannot take the allowance and absorb into the base pay just to beef up to 1,007. Okay, Eugene asks, may I know what is maternity allowance? Now, the maternity allowance is the same wages you pay. When they work, you pay them salary because they are working. But when they are on maternity, they are not working. So we don't call it wages. So we call it as allowance. It's the same amount. Let's say if you're a full-time employee, your basics, your monthly salary is 2,000 ringgit. So when you work, you get 2,000. But when you go on maternity, you also get 2,000, but it's called allowance, not wages. So when you're working, it's 2,000 ringgit wages. When you are on maternity, same 2,000 ringgit, but it's called allowance. It is not two different payment. Okay, yep. If it's a 5-day work, more than 8 hours, how do we get consent? Now, the law says the maximum hours work per day is 8 hours. If anything more than 8, the employee and company has got to acknowledge. They both have to agree. So you should go back to the employee saying that we want to increase the hours to 9, but you got to agree to this. So if they don't, then there's an issue there. Can you explain the break hours included part of working hours? Now, this goes back to your employment contract. Some employment contract, it is stated like this: your work hours includes 1 hour lunch. Now, this is a bit tricky. Sometimes when we draft the clauses, right, you got to be careful when we say include and exclude. Of course, EA says the break hours are not part of work hours. So if during break hours, they are away, they are in the canteen, they go and makan, they're doing whatever they want, they're not working. So that is not work hours. But if your contract, if you mention this, your work hours includes 1 hour lunch, and if you write it differently, your work hours excludes 1 hour lunch. So this include, exclude can give you a totally different meaning. So Hilmi, work hours is not, but how have you drafted? How did you draft your work hour provision in your employment contract? Exclude or include? Part-timer, does all this leave need to be prorated? So Kenneth, I would encourage you to go to the Facebook community, our Facebook community group. Myself and Haji Hussein, we have done a comparison of full-time, part-time. What is the entitlement? Of course, it is not the same, right? So full-time, they get how many days of annual leave? Part-timers, they'll get a reduced number. So to answer this, you can either refer to the part-time regulations, which has got all these answers, or go and look out for the comparison. So I hope all of you all, right, if you are in our Facebook community page, please don't be lazy. Please do some search, right? Go to the search button, search for comparison, follow the discussions. Now, if you guys really want to be, you really want to be in control of your job, you want to be on top of things, you got to spend time and effort to read, to learn, to engage in discussion, right? In fact, many of these questions you ask, we've already discussed numerous times, but some people, they just don't have time. They got time for movies, etc., but they don't have time to read, right? Please read because it helps you a lot. So tomorrow when your boss asks you a question, you're able to, provide answers without even asking or referring here and there. Okay, so there's a question from Rachel. Part-time total work hours is 70% from full-time hours. Are they entitled to allowances? That depends on your contract. If your contract you provide, yes, you provide. So a lot of these allowances, right, it all depends on your terms of engagement. If you mention in the contract, even as a part-timer, you're provided allowances, you got to give. But if you don't give, then don't mention it. Just say that as a part-timer, your salary is this much, and this is your work conditions. That's it, right? If you give allowances, or you mention allowances, you got to give. Okay, scroll down. Okay, now, Lalita asked this question. If the HQ is in KL, and the branches are all over Malaysia, all over West Malaysia, can we take a foreign workers permit under HQ and send it to work? I don't think this is allowed, right? I don't think labor allows it. I don't think immigration allows it, because in the work permit, it is printed, it is stated where is the work location. I can tell you, if the authorities were to come and visit you and they look at the passport, it says that this person is supposed to be in Kuala Lumpur. What is he doing in Johor? Right? So you got to be careful. I would encourage you, Lalita, to get further clarity from labor or immigration. Okay, next. Okay, so there's a question from Nurul Nadra. If I pay a friend to support, let's say to do recruitment for the company, no tracking, no work hours, that means it's very flexible. She just needs to revert 8 to 10 resumes for interview every week. Will that be determined as a part-time employee? Her payment perhaps will be invoiced based on agent fee. Now this, in my view, is not an employee. So what do? You engage them as a freelance contractor. Contract for service, not contract of service. Contract of service is employment. Contract for service is how you engage a contractor, right? So this case, Nadira, you should hire this person or you engage them on a contract for service, so they raise an invoice to bill you for the services provided. Okay, can the company convert overtime to replacement leave for those earning below 4K? Answer is no. EA do not provide this, this direction. If they are in the green box, remember the green box? If they're in the green box, if they work on Sunday or the rest day, public holiday, or they do OT, you got to pay them OT. Cannot convert into annual leave or replacement leave, cannot. So if you are doing it, Nabila, you are breaking the law. Okay, this, the presentation slides will be shared in Facebook group. So after this call, go to our Facebook group. You can watch this recorded webinar and also download the slides. Okay, in Sabah, we have a student called work-based learning for 40 hours a week. They fall under apprentice or internship because they will be having semester break. Now, if they are at your place as part of a diploma for a period of time, right, that is not employment, right? If they are already completed their diploma or degree and they come and work for you, that could be part of apprentice. But I would encourage you to just double check with Labor Department, see whether this falls into apprentice or otherwise. How about Indonesian maid? Permit as maid. They do cleaning for director house, also been asking to cleaning for office. Will the salary follow minimum wage? Now we know that domestic workers, they do not fall under minimum wage. But if you brought them in as to work in the factory, etc., then minimum wage shall apply. So, okay, there's a question from Hani regarding the amendment to first schedule. Certain provisions do not apply, like Section 60J do not apply to those people earning above 4. Does this does this imply that employees earning above 4 are not entitled to termination layoff? Answer is yes, but not necessary above 4. If they are manual worker, the green box, remember the green box, red box? So those people in the green box earning above 4, you got to pay them termination benefit. But those people in the red box earning above 4, you don't need to pay if you don't want to pay, right? So it's not, so sometimes when we say above 4, no need, you got to be very careful here. If they are manual worker, it doesn't matter whether they are below 4 or above 4, termination benefit is applicable. But if they are not a manual labor, they are not supervising manual labor, they are not also running any of this mechanically propelled vehicle, but earning above 4, then this group not applicable. So remember, green box, red box. I find it's easier to explain, green box, red box. Okay, next. Okay, so now, Priya, if company cuts off salary by 10%, shorten the working days to 4 days a week, but have stopped FWA, right? That means the company reduced the salary by 10%. Instead of 5 days, they work 4 days, and they no longer they don't call it FWA. All are executive working in the company. Can the employee still apply for flexi work? Can the employer still reject? You can apply, right? It doesn't stop just because you're working 4 days. It doesn't stop it does not stop you from applying. But end of the day, it depends on whether the company want to approve it or the company wants to reject the FWA. If the company is going to reject, the law says the company must inform you in writing within 60 days, right, after approving or rejecting. So you apply, 60 days, approve, reject. If reject, the company needs to explain to you why the application for FW is rejected. So it doesn't mean that 4 days work, you cannot apply. You can, but maybe you should talk to your company. What is the objective of 4 days and why not 5 days, right? I think 4 days is only some kind of flexi work, if you ask me. Okay, so Sean, flexi work hours, like I said, flexi work means, right, the work is flexible, the hours are flexible. For example, like what we know, very common practices, you come in at 8, you go back at 5. You come in at 9, you go back at 6. You come in at 10, you go back 7. So the hours are flexible. You still work 8 hours per day, but you come in early, you go back early. You come in later, you go back later. So that's one form of flexi work. Break time includes in 8 hours. Answer is no. But if your employment contract, if you have mentioned, is included, then included. So I advise in your clauses, make it very clear. Your work hours is 8 hours or whatever hours, excludes lunch break of 1 hour. Put the word excluding so that no confusion. So, but of course, if you read EA, if the hours they are away from work, they are not working, that is not work hours. But again, those employees who cannot leave their workplace, let's say a guard, he's got to be there all throughout. Now, for him, the break time is part of work hours because he cannot leave, right? While eating, he's got to look after the counter, right? But those people who can go away, they can go to the next nearby coffee shop or restaurant to have their meal, that is not work hours. Okay, what is the difference between SLO and EA? I would say most of the items are quite similar except for maybe public holiday. Sabah Sarawak has more public holidays than local. One or two other provisions, but generally Sarawak Labour Ordinance, Sabah Labour Ordinance are quite similar to EA except for some provisions. Yun, we had a seminar just recently in KL here, our academy here, a half-day seminar on Sarawak and Sabah Labour Ordinance. I think you missed it. You should attend all this, right? It's a free seminar, right? You pay for a meal, but the rest is free. You should attend this because it helps you. In fact, it is not a webinar. It's not a seminar. It was a webinar, right? It was a webinar last Thursday, right? On Sarawak Sabah Labour Ordinance. You guys should really focus and follow, right? Half-day webinar for free. What is SLO? What is EA? What is the differences and so on? Okay, so there's another interesting question. EA versus ILO versus RBA can be used in organization. Now, EA, Employment Act, if you're in Peninsular Malaysia or Sarawak Sabah Labour Ordinance, if you're there, now EA applies to all companies, right? But some of y'all, you might be subscribing to certain social compliance standards. If you're in semicon, the glove industry, electronics industry, palm oil, oil palm industry, etc., some of y'all, you are being audited by your clients and your client tells you, I want you to follow RBA standards. Now, RBA standards are more stringent than EA. For example, RBA standard says that the total work hours, including OT, in a week cannot exceed 60. But EA, you can exceed. So RBA standards are much more stringent. So if you are subscribing to RBA, your client says you must do RBA, then you got to follow RBA. If you are following RBA, you are already complying to EA. EA is very basic, right? RBA is much more stringent. Okay, companies do not provide compassionate leave to interns. Well, interns are not employees. You can do whatever you want, right? You can also choose not to give annual leave or sick leave, etc. Because they are not employees. They are not governed under EA. So EA terms do not apply to those interns coming from, a degree program or a diploma program, right? So that's on interns. So EA does not apply to interns. Okay. So those employees earning above 4K in the red box, they are not entitled to retrenchment benefit. You're right, Melvin. They can be easily retrenched. Well, it's not that easy as well. If those people in the red box, if the retrenchment is not genuine, right, that means the retrenchment is done with a bad intention, this employee can file a case under Section 20 of IR and claim to be unfairly dismissed. If the employee wins the case, he will get 24 months back wages plus 1 year, right, for 1 month payment in lieu of reinstatement for every year. So if he worked for 10 years, he will probably get 24 plus 10. So you don't pay termination benefit, that's fine. But if the employee files a case, and if you're not able to prove as an employee, as a company, if you're not able to prove that this termination is a genuine genuine retrenchment, you lose the case. You lose the case, you pay 24 months plus. Okay. Next. Okay, supervisor asks HR to read out the warning letter in front of accused. Does this constitute discrimination? Now, I don't think it's an issue of discrimination, but probably issue of fairness, right? Fairness. I'm not sure whether, if you bring this to labor, whether labor is going to entertain this case, but there could be a possibility, right? If this is being done repeatedly, right? Not just first time, second time, third, and always done repeatedly, I believe this employee can file a case of constructive dismissal. I could be wrong, but he can file a case. But if it's a repeated offense, why should you embarrass this person, right? You embarrass this person in front of others, right? To me, Shukri, this supervisor, if I were you, I will take a very firm, very tough action on him, right? He is going to cause damage to your company. So if you're Shukri, if you're HR, why are you allowing this supervisor to read warning letter in front of others, which is wrong, right? Please take action on them. Do not allow people like this to Maharaja Leela in your company. Okay, next. Okay, flexi work. If the company allow, so let me see, for flexi work hours arrangement, does company allow to just mention is rejected without any explanation? No. What it says, if the employee applies for flexi work within 60 days, you must either approve or reject. If you're going to reject, you must explain to them in writing why it is rejected. So you got to give them the reason for the rejection. Okay. So there's a question from Winnie. Is there any minimum work period for an employee to be entitled to prorated annual leave? If the person worked for 2 months, decide to resign, the employer eligible to provide. Now remember this, if you go and read the annual leave provision in EA, it says this, an employee shall be entitled to 8 days after completing 12 months of service. So that means when they complete 12 months, they become eligible for 8 days. But what most companies do, they give it from day one, but it's prorated. So if an employee, after 2 months, you don't give annual leave, he resigns, you got to pay him back the prorated leave for the 12 months. You got to pay. The law says you got to pay, right? So if you don't give, they resign, you got to pay. Okay, maternity allowance need to fill up any specific form. Well, I think many of you all may not be aware of the another regulations. So please write it down. If you have a paper and pen with you, please write this down. Employment Regulations 1957. Right? Please write it down. Employment Regulations 1957. It's a very old regulation, still in force. If you want a copy of this regulation, you can either get it from Labour Department's website or you can come to the Facebook group. You can search this in the search box and it'll appear. Now, one of the conditions, one of the items mentioned in employment regulations is to maintain a maternity register, right? It's not to submit to Labour Department, you got to maintain a maternity register. So if Labour were to audit you, they come and say, can you show me all the maternity register? You got to show it to them. So that is part of employment regulations. Now, employment regulations also says this, your pay slips, should it be in hard copy or soft copy? Right? So please read the employment regulations. I think many of you all, if you're giving pay slips in soft copy, acceptable or not, right? Employment regulations will tell you this, right? Terma kerja should be in what format, right? So please read employment regulations. If you're giving soft copy pay slip, all of you all, please read employment regulation 1957, whether you are in line with the law or not, right? Maternity allowance subject to statutory deductions, yes, right? Because you see, remember this, EA is EA. EPF have their own act. So for EPF, allowances is also considered wages. Allowance is also considered, for what do you call that? Deduction. So Yun, if a female worker takes maternity leave and returns to work after 60 days, so 98 days, the employee only takes 60 days. So what happened to the balance 38 days? So if she come back, right, you got to pay the 38 days, plus you got to pay the salary as well at the same time. So they get two payment. If you're not going to pay me this, right, why do I want to come back? I rather rest at home. I rather finish my 98 days and come back. So there's no carrot for me to come back, right? So you got to pay. Because why? The allowance is their entitlement. So Wati, the presentation today, will it be shared in LinkedIn? The thing is, we don't share in LinkedIn because LinkedIn don't have a file mechanism like Facebook. So I would encourage you to join Facebook, right? It's okay if you know, a lot of people says, I'm not in Facebook. Guys, if the knowledge is in Facebook, why are you not in Facebook? Create a Facebook profile. Don't tell anyone you're on Facebook. Why are you going to tell people you're on Facebook? If your name is something, you put like your name is XYZ, right? So because Facebook allows us to put the files in the file section so people can always refer. The problem with LinkedIn is LinkedIn don't have this function. So I would encourage Wati, come to Facebook. The link is shared by my colleagues, right? And do it. Now, engineer. Is engineer manual worker? In my view, no. Manual workers are those people who are doing repeated job. They're not highly trained. They don't make decisions, right? They don't use creativity. Those are manual workers. But engineer, I don't think is a manual worker because they go through a degree. They are highly trained, right? So engineers are not. Technicians can be considered manual worker, but not engineers, right? So this issue, this discussion of manual, not manual, is a bit, sometimes it's a bit difficult to understand. So a lorry driver is a manual worker, but a pilot is not a manual worker. A cook in a restaurant, this kedai mamak cook is a manual labor, but the chef, in a 5-star restaurant is not a manual labor, right? So I'll be sharing these slides with you. There's 2 links, right? Go to the link. One is by Donovan and Ho. I think they've done a nice write-up. And another link, I can't recall by who. So read these links because it gives you the description of what is manual, what is not manual. Okay, so let me just take one last question, if you don't mind, because because it's time's up. There's a question by Tamil Selvi. Let's say the staff salary is 4001, terminated. Can she file a case in JPP or JTK? She can go to both, right? The purpose of JPP is to file for unfair dismissal. They may go to JTK because they may say that you terminated me, you didn't pay me my annual leave and notice period and whatnot, right? They can go to both. Usually, if they go to both, they'll be advised you settle one first, then you come back to the other, right? So Tamil Selvi, I would encourage you to go to the forum. There is a write-up done by me and Haji Hussein on, filing a case in JPP, JTK, for what purpose, how does the process work, right? We have done this write-up in the forum. Please read it. you will find it very useful, right, to answer your question. Okay, Melvin, just go up a bit. Just go up a bit higher a bit. I'm not sure which question by Melvin. Okay, down. Okay, maybe I'll just pick one last question. Okay, Fatin, part-time worker, if they pay them hourly, daily, do you need to pay EPF and SOCSO? Yes, because EPF and SOCSO Act do not exclude them. They are employees. You got to pay EPF and SOCSO. Okay. Yeah. So FWA rejected. Can employee find a reason provided by employer as unacceptable? Well, you see, the problem is there is no appeal process. If the company rejects, it's rejected because the law only says the company should either approve or reject. If rejected, why? That's all the law says. The law do not give a provision for appeal, right? You can have an appeal process within a company, but if there's a discrimination, two employed in the same job category, one got it, one didn't get it, now that one is an issue of discrimination. Okay, so I think we are at 4:36. So I think we may have to stop here, right? We may have to stop here. So I would encourage all of y'all to get a copy of these slides in the forum. And when you come to forum, many of the questions you ask, my colleague scrolling these questions, a lot of questions. Many of these questions we have already answered in the forum. There are even write-ups to explain many of this. So I would encourage all of y'all to join the Facebook group, right? Links are shared by my colleagues. You'll find tons of documentation. There are 45 HR policy samples in the forum, 100 over forms and templates, right? Documentations, FAQs, recorded webinars, questions, right? And of course, like what me and my colleagues do, whenever there's something new in the market or something news, a new news, case awards, we quickly share it in Facebook, we discuss, right? Members will share, ask, etc. That is one way to learn, right? We need to read many scenarios to learn. So just imagine a doctor in a hospital. The doctor need to see how many patients before he can become a real expert. If I'm a doctor, if I only see one patient per day, in 1 year I see 300 patients, can I be a real expert? Or I see so many patients. So some of the doctors who see many, many patients, they are very, very highly skillful, right? So much so, when you go and see them, by just giving a brief description, he knows, okay, I know your issue. That's a very experienced doctor. So a very experienced HR practitioner, you must understand all the various scenarios that can happen. So where do you learn all this? Facebook group. You can go for training. Training is only 2 days. And the trainer, he may not be able to cover all the scenarios in 2 days. Learning doesn't stop by just going for 2-day training. 2-day training is to build your basic foundation, but you got to continuously read scenarios. And I can tell you this, right? Not that I'm bragging or boasting, but you will never ever find a platform like Malaysia HR Forum anywhere else. Nobody in Malaysia has this platform. Nobody. So the only platform is in Facebook. So if you want to maintain this standard, oh, I'm not in Facebook, etc., I'm so sorry, but you're losing out, right? Create your Facebook profile. Don't tell anyone you have a profile, and learn up. Join Facebook group, right? Okay, so thanks a lot for listening. And next week, we got 2 more webinars. One is on a masterclass recap. I will cover on public holidays, Section 8, Section 9. We will cover on some of the provisions of, how do you terminate, notice period, probation period, what are the scientific approach. Probation period, sometimes we say it's very difficult, but I've got a different method altogether, right? How do you manage it? Who should you extend? Who should you not extend, right? So we'll cover all of those next week in the masterclass recap. And we have got another webinar, which is called Definition of Wages. How do you define wages? OT, ORP, right? And so on. So that'll be next week. What is the difference between traveling allowance and transport allowance? So that is for next week. So I encourage all of you all to join us in the session next week. Now, the masterclass recap, get your bosses to join in as well. Sometimes the bosses don't trust you, right? When you tell them, boss, cannot. You call a lawyer, call this, call that. Now, they don't trust you, but they may trust me. I'm an outsider. So what you can do next week, book your manager's time, tell them, Next week, I can't recall what was the day. Come to the meeting room. I want you to watch this webinar, right? Okay, so thanks a lot for joining us. I hope this 1.5 hour or so is useful. And please download a copy of this, right? So next week webinar on masterclass recap is 3 hours. It's a long webinar. We'll cover quite a lot. I can answer many of your questions there as well. So if you can join the masterclass recap, you can ask some of the questions that I could not answer today. I will be able to answer that in the masterclass recap because we got longer hours there. So thanks a lot. And for the Muslim colleagues, selamat berbuka puasa and an advance selamat Hari Raya. Thank you and see you next week.
I would like to take this opportunity to thank Malaysia HR Forum for organizing this AHRP program. I'm also very thankful for the chance to meet many wonderful like-minded people here throughout the program.
Okay, so I also remember about the advice from the CEO of Malaysia HR Forum, which is Mr. Kumar. He always says about AKS, attitude, knowledge, and skill.
So first job, don't berkira-kira, work hard. The first 10 years of your working life, and what I've said the other day, the first 10 to 15 years of working life, it's all about hard work. So first job, grab what you can first, take it up, build your experience, build your competencies, learn the skills that you don't have today. The time will come when something will tell you that it is time to move on.
So you have to remember that having qualification doesn't really guarantee you a job, but it can land you with one. But for you to continue climbing the ladder, it's all about skills. And when we talk about skills, of course, not just soft skill, communication, writing, but relates to what you're doing.
What happened between that time until now? I never quit, never lie, and I never want to be somebody other than myself. So if you're a boring person, be boring. If you're an animated person, make sure that animation comes out. And if you're a person that is shy, so be it. The moment you lie, the moment you say you know things and you don't, that's when you won't get the job. At that rate, by the time you are 30, you're going to be having a salary of 7,000 ringgit. Congratulations. But 7,000 doesn't cut it in KL. Learn, continuously improve yourself. This AHRP paper is one of them. Continue to add stuff in your CV.
As a HR professional for many years, the AHRP program, the quality of candidate that we see today, they are well equipped with the confidence, the knowledge and skills of HR, what is it to be a HR person, and all of them coming from other background.
I'm very thankful for Malaysia HR Forum by giving us this opportunity to interview some candidates that they have trained in a 5-day program, and they also filtered the candidates based on their own requirements. And I would say that this is a fresh batch of candidates for us to interview. So it was good, and in a couple of days we will shortlist some candidates and hopefully to organize a second interview with them.
When I first saw it, I thought it was a really good idea to bring candidates together with a specific specialization, which is why I wanted to participate, because I've got HR needs that I'm looking for. So it was a good platform for me to meet a good pool of candidates who have a certification that I can work. Some of them are meeting expectations. As an organization, I'm looking more towards the ability to communicate, looking at critical thinking, character and motivation of the people. So I think for the most part, I've met good people today.
Overall, it's a good experience to participate this HR Recruitment Day. And I think it's a very meaningful event that helps the fresh graduates out there to have the employment opportunity. Overall, I find the session very fruitful, and we managed to get a few good candidates, and we are going to shortlist for the second interview with our company.